Welcome to Kanuni Charcha. Today I will delve upon today's judgment. Today's judgment has been pronounced by Honorable Supreme Court of India. The title of the case is Just Rights for Children Alliance and Another versus Harish and others. This is a judgment. This is by Supreme Court of India in criminal appeal so and so arising out of special leave petition so and so. This judgment is relating to section 40, section 15, section 30 of protection of children from sexual offences 2012. This is the original act, but this act was amended from time to time, particularly with which we are concerned here. It amendment was made in the year 2019. This is with regard to section 50. Some new provisions were added by this amended act 2019, POCSO. Now I will and 30 of POCSO, 14, 15, again I will repeat 14, 15 and 30 and section 67B of Information and Technology Act. Well, the facts of the case: a FIR was lost on 29th of January 2020 with the police station, all women police station, Ambattur, Chennai, for commission of offence 40, 1 of POCSO and 67 of IT Act, 67 B of IT Act, Information and Technology Act. Under these two provisions of law, the FIR was lodged with the women police station, Ambattur, Chennai, and matter was investigated against the respondent number 1, Harish here. After the investigation, the offence under section 15 of POCSO was proved with section 67B of Information and Technology Act. During the course of investigation, the mobile phone of the accused was seized and it was sent to FSL for analysis in order to find out whether it is containing some pornographic material, and if so, whether it has been used. This is and other you will find a detail for which and this the mobile phone was sent to this FSL. After receiving this forensic analysis report, the charge sheet was filed before the special judge. Instead of facing the trial before the special court under POCSO Act, the accused preferred to approach the Honorable High Court of Madras for quashing the proceedings initiated against him by way of FIR, and which was culminated into filing of a charge sheet by the after investigation by the investigating agency before the competent court of law. Now, what was the impugned order which has been, this is a Madras High Court's order, very important. You might have heard and you might have read that there was a order of Madras High Court Madras High Court, that was with regard this matter, which has now set aside, quashed by today's judgment. This which I am discussing here. I will read out para 10 of this judgment. Para 10. The impugned judgment of the High Court is in three parts. In other words, the High Court quashed the criminal proceedings essentially on three grounds. First, the High Court of the view that to constitute an offence under Section 14(1) of POCSO, child must have been used by the person accused for pornographic purpose. Use of the child. Well, it was the viewpoint of this Honorable High Court. It observed that although the two videos depicting children engaged in sexual activities were found to have been downloaded and stored in the mobile phone belonging to the view of the Madras High Court of the view that unless there is a publication, there is a transmission of the pornography material and its publication, no offense is made out. Storage and viewing of this pornography material, it may relates to children, does not constitute any offense. This is finding of this finding has been assailed by way of SLP and that was converted into this criminal appeal. The Honorable Supreme Court of India, in the present case, on taking into consideration the viewpoints, the findings of the Honorable High Court of Madras, framed the issues that are you will find in para 38 of this judgment for determination. The issues, but what were the issues? I will read out. You will find in para 38. What is the scope of Section 15 of the POCSO? In other words, what is underlying distinction between subsection 1, 2, 3 respectively of the POCSO? Now, whether mere viewing, possessing or storing of any child pornographic material is punishable under POCSO? This is also a question framed and it required to be answered in this judgment, and accordingly it has been answered. What is the true scope of Section 67B of IT Act? This is also a point framed, raised for decision. What is the scope of Section 30 of POCSO? In other words, what are the foundational facts necessary for invoking the statutory presumption of culpable mental state in respect of Section 15 of the POCSO? Now, this is also whether the statutory, this is a fifth point framed, whether the statutory presumption contained in Section 30 of the POCSO can be invoked only at the stage of trial by the special court alone established under POCSO. In other words, whether it is permissible for the High Court in quashing petition filed under Section 4A2 of Code of Criminal Procedure to resort to statutory presumption of culpable mental state contained in Section 30 by the now I think it is appropriate for me to read out. I have already referred by touching the factual matrix as referred that FIR no doubt was filed, registered for commission of offence under Section 14 of this POCSO, but after investigation, police proved, investigating agency proved the commission of Section 15 of the IT Act. Now, I will read out the very important Section 14. First, I will read 14 and then I will go to punishment for using child for pornographic purposes. This is heading, it is clear that if some a child is used for pornographic purposes, then this Section 14 is attracted. Now, I will go to Section 15 of the POCSO Act. This I have already mentioned that amendment was made to this section by Amendment Act 2019. Now I will read out the section 15, punishment for storage of pornographic material involving child, means child related pornographic material. Any person who stores. Now the Supreme Court of India drawn a finding here in this case that it is sufficient for having a criminal proceeding for commission offense under section 15 of the POCSO if somebody is found containing, storing, possessing pornographic material. Now they have found the accused, this respondent number 1, liable for punishment. This liable not for punishment, liable to be have a criminal proceeding against him under section 15 of the act. Now I will read out that. Any person who stores or possesses pornographic material in any form involving a child, what fail to delete or destroy or report the same to the designated authority as may be prescribed, with an intention to share or transmit child pornography. Mean with an intention is also there. Their storage, by he has kept the pornographic material in his mobile phone. By he is possessing this material. His intention is to, unless he destroys or report about the availability of the this pornographic material to the designated authority. If he do not omit to do that, if he intentionally do not do that, it means that he is liable for, shall be liable to fine not less than 5,000 rupees. In other words, in crux of this section appears to be that if somebody is found having storage of or possessing of the pornographic material in any form involving a child, he is liable to be have a criminal proceeding against him for commission of offence under section 15, and he is liable to a fine of rupees 5,000, and in event of second or subsequent offence, then he is double the amount, 10,000 rupees, liable to have a fine. This is with regard to storage and possession. Now the subsection 2 and subsection 2 deal with any person who stores or possesses pornographic material in any form involving a child. This is aggravative form of for transmitting or propagating or displaying or distributing in any manner at any time except for the purpose of reporting as may be prescribed, or for the use of evidence in the court, shall be punished with imprisonment of either description, which may extend to 3 years. Now this offence, this subsection is having more grave than the earlier subsection. This is because by he has stored the material in order to transmit or propagate or display or distribute. This is with regard to early. Now here the prime consideration is to prove the intention of the accused, that why he has stored and kept the material. The intention depends upon conscience mens area, and the relevant section as discussed in this judgment is they have referred as section 30 of mental state of an accused. Then no doubt there is a presumption in favor of that whosoever is possessing, there is a presumption against the accused, but this presumption is rebuttable by the accused. As per criminal jurisprudence is to be proved beyond reasonable doubt in the competent court of law in due course of the criminal proceeding. But many presumption, or generally speaking, every presumption is rebuttable. The accused has a right to prove and rebut the presumption by way of leading evidence in defense, as can be done in this case also. In the due course of proceeding before the trial court, he can reflect what was his mental state, what he wanted. That mental state of a person can be divulged by the person concerned, but nobody can enter into others' mind. But thing speaks, inference can be drawn. This is also, yes. Now let us come to subsection 3. Any person who stores, possesses pornographic material in any form involving a child for commercial purposes. Now, here the punishment provided is minimum is 3 years, and it can be extended to 5 years. So this is section 15. In the present case, the Supreme Court of India have found has set aside the judgment and findings of the High Court of Madras earlier, by which the criminal proceedings initiated before the such special judge was quashed. Now you will find that many judgments of different high courts, different point beats have been available in this, and a long and suggestions have also been made to the government in as per this judgment. To now, the crux of this judgment, conclusion drawn of para 260 of this judgment, some suggestions have been recorded, and Union of India and courts concerned, special courts, were directed to comply with. You will find a detail here what were the suggestions and directions made to. Now I will come finally to what have been decided in para 261. For all going reason, we have reached the conclusion that High Court committed an egregious error in passing the impugned judgment. We are left with no other opinion but to set aside the impugned judgment and order passed by the High Court and restore the criminal proceeding in the special so and so proceeding so and so to the Court of Session, Mahila Niti Madram, Fast Track Court, Thiruvallur, District of Madras, I think, be accordingly pass such order by the already mentioned. But I want to read out the section 30, presumption of culpable mental state. Culpable mental state. In any prosecution for an offence under this act which requires a culpable mental state on the part of the accused, the special court shall presume the existence of such mental state, but it shall be a defence for the accused to prove that he had no such mental state with respect to act charged for as an offence in that possession. So then, but prosecution is supposed to prove the existence of facts, allegation which would lead to commission of offence beyond reasonable doubt, and not merely when its existence is established by a preponderance of probability. Prosecution is supposed to prove the offence under POCSO beyond reasonable doubt. In this, culpable mental state includes intention, motive, knowledge of effect, and we have order. So, in short, that this section 30, I have repeat again, can only be invoked before a special judge, and not such a presumption as available under section 30 can be invoked before the Supreme, this Honorable High Court, as has been done in the present case by the Madras High Court. So I think this is sufficient for today. Till then, thank you. Thank you much.